Welcome to the Tunabudget podcast, your source for insights into financial wellness. Today we're diving into estate money to siblings and or grandchildren. At Tunabudget.com, home of the Tunabudget worksheet plan and candid conversation memos, we offer resources that simplify budget life planning. We encourage discussions about real-life challenges affecting our finances. Don't forget to submit your candid conversation memo at Tunabudget.com. Let's get started. The purpose of this candid conversation memo is to illustrate how a simple estate trust can become a complicated matter. It endeavors to guide survivors to be civil and respectful and to carefully consider the mind and the heart and the will of all those that left the assets for the benefit of all the beneficiaries, the children, and what they would want. In other words, trusts may not be perfectly written. Expectations can be shattered as the realization sets in that assets may not be dispersed as you might think or be planning on. Things change over the years. Trusts may not be updated to reflect those changes. This is likely to be a messy season of wealth transfers, something that will require some humility, especially in the event your expectations do not come to pass. This will increasingly become more and more important as there will be some $68 trillion in assets to be dispersed over the next 25 years. And that's according to the Sorelli Associates report on the Great Wealth Transfer by Sorelli Associates Wealth Transfer Report. We, the people, be warned, okay, to put on our better manners and handle these wealth transfers with the utmost care and order, else things most precious and enduring will be lost to tangibles that will themselves turn to dust one day. Let me give you a simple hypothetical example of what I'm talking about, how things can get messy. Take a look at a scenario where a trust, okay, the grandpa and grandma or the mom and dad, the old people, have a single mortgage home, basically, that as its sole asset. There might be a car and a few other little things, but let's just say it's the house for all intents and purposes. And upon the death of the last parent, okay, the sales proceed would be dispersed to the deceased's three natural children, say 2 daughters and a son, or at 33 1/3 each, okay? One of the daughters is the trustee, that one person that will administer the trust, right? Has the legal authority to assign and so forth, sell the home and what have you. And she intends to disperse the sale of the proceeds to each sibling as their parents wanted it. The trust grants her some discretionary authority as needed. And let's assume that the trust has never changed or updated up through and including the passing of the last parent. So it's been there for like years. Sounds simple and straightforward, right? What could possibly go wrong? Now let's say these siblings and their spouses have been quite close to each other for decades, including all the grandchildren or the cousins, right? Once the parents are deceased, each of the 3 siblings expects to receive their 1/3 of the estate per the trust document. However, some things have changed. What if 1 or 2 of the natural siblings became deceased prior to the time the last of their parents becoming deceased? Say the other daughter became deceased first, okay? There are only the 2 surviving siblings, the trustee daughter and the son. You may naturally conclude that the 2 survivors would then split the estate 50-50, right? After all, the parents wanted their estate to be passed to their children, and there were only 2, and now there's only 2 survivors left, right? And that's what the trust states. And the estate will go to their children, right? That's who's going to get it. It didn't state what would happen to a child's share if one of them were to become deceased. Now, let's go deeper, okay? If you are either the surviving daughter or son, would you then want or expect to be given a 50% share? I can hear you say yes, of course. Would you feel justified in getting the larger share because you are one of the remaining survivors then? How do you feel inside about the fact that your surviving widowed sister-in-law or brother-in-law and their family didn't get the 1/3 share they were expecting but lost out because their spouse, the original beneficiary, happened to have passed away sooner? But would you feel completely different about the disbursement if you were the sibling that were to die and you expected your share to go to your spouse or children instead of that 50-50 split that you wanted earlier as an actual survivor? Let's raise the bar further. Let's say the other sibling's son also prematurely died before the estate was settled. The sole surviving sibling would be the daughter trustee. Would or should she then get the entire inheritance? What would the other surviving families of the deceased siblings think about this? Let me throw out some questions for you to consider, okay? Since the trust is not all that clear for instances like this, the trustee will have to use some of that discretion as allowed, or could use some of that discretion as allowed by the trust. So put yourself in the position of each of the three siblings, or the spouse of the siblings, or even one of the grandchildren as you consider the following specific questions. Okay? Put yourself in all these positions. Here's the first question, what about all the proceeds being dispersed solely to the surviving two siblings or just to the sole surviving sibling? Would not the deceased siblings have wanted their share, so to speak, to go to their surviving spouse or natural children? Even though the trust was not updated, would the deceased parents have wanted for their estate to be divided up three ways, with the proceeds being dispersed at least to their natural grandchildren? Or even to the in-law spouses, who may get remarried, right? And the grandchildren potentially never seen any of the benefits passed down to them for decades. Especially if two of the natural siblings died and nothing was mentioned in the trust for such a happening, right? What happens? Even though the trust was not set up to address such situations, would the parents really have wanted all 100% to go to just one surviving sibling, with no benefit at all to go to the other families or their grandchildren? Should the three siblings be entitled to have their share go to their surviving spouse or natural children? As very close families, would the surviving siblings or their spouses not want their deceased spouse's share to go to them, if not their children? Would they think that the deceased parents in no way would have wanted 100% to go to a sole surviving sibling, but to do the right thing and disperse it to the other natural grandchildren at a minimum? If the surviving siblings per the trust were to get whatever proceeds they might receive, be it at 1/3 or half or 100%, depending on who's surviving, would it make sense to give something to the surviving family spouses or even the natural grandchildren, if not their full shares? The amount would have to be determined in the same spirit of doing the right thing. How would you handle these discussions if you knew your opinion differed from those of other family members? Would your opinions change at all if the daughter trustee were to become deceased and you or the other sibling were appointed as the new trustee? This short ad is sponsored by the Debt Crisis Problem Podcast. Attention listeners, please join us at Tunabudget.com to tune in to the Debt Crisis Problem Podcast, where in plain English we discuss the 20 risks that could soon fuel a serious economic downturn. We explore these critical risks and offer practical insights for navigating financial uncertainty. Join us for thought-provoking discussions that encourage transparency and more awareness. Subscribe now to stay informed and be ready for whatever comes next. Obviously, because the trust did not address the issue of a deceased sibling or siblings, the trustee with its discretion authority will have final say on the disbursement of the trust funds. In other words, it is possible as estate assets are settled, there could be instances where legal documentation is either incomplete or considered to be misguided. The trustee will have to resolve the issues, and hopefully in the best way possible. Meanwhile, what might a family member do to address such questions? Do the surviving siblings, the named beneficiaries, get together and provide input into how they think the proceeds should be handled, subject to the final discretion of the trustee, of course? Or would it be better for the trustee to just make a final decision and advise the family members how the proceeds will be dispersed? Will you or another sibling try to get the aged surviving parents or surviving parent to change the name of the current trustee to a different sibling? Would that attempted maneuver dishonor the wishes of the prior deceased parent? In the end, after funds are dispersed, couldn't any of the beneficiary payees who may have felt funds should have been dispersed to another party simply write a check with some of the money they received to such persons, especially if they didn't need the money? This is really an important discussion because on one hand, the trust speaks for itself, right? But the trust is not perfect, as noted. Fortunately, the trustee has some discretion to make some decisions of how she sees fit. In fact, the trust also states that if any beneficiary contests the trustee's decision on how the trust is dispersed, the trustee is allowed to forfeit the interest of such a beneficiary. That clause itself could cause a host of problems, too. Family discussions on estate matters will likely become more formalized in coming years as more and more attention will be paid to the baby boomer generation until it passes on. That's $68 trillion. Until then, we may experience a decade of family fun, right? The process will likely be very delicate. Finally, cases will obviously vary, right? Depending on asset size, whether legal representation will be included or not, etc. Generally speaking, most cases will not be overly complicated, but possibly subjected to unique nuances like the ones presented in these cases. Let me give you another case to consider, though, okay? For example, this would be, of course, in the absence of a trust now. What if one of the siblings' names was added to the title of the residential real estate ownership of the aging parents, say many years before the last parent became deceased? As the last parent intended, it did this so that it could help facilitate the settlement of this estate for the surviving siblings, right? It was all done in good faith so that it could facilitate things. And suddenly the last parent dies and one of the siblings owns the residence. Now what? From a legal perspective, there is no inheritance. The sibling owns the home free and clear, and nobody can do anything about it. So what are his or her intentions? And how do you bring it up after maybe 6 months goes by and nothing happening? And what if the house is sold even at a very high price and not a word is said to the other surviving siblings for another 6 months? And that sibling is taking expensive vacations and considering major home improvements. Now what? So you get the picture, right? Well, I have several candid questions in summary here that I'd like to share with you just for your consideration, okay? If you're not careful, could you be part of the problem here and not the solution, right? What are you willing to do to help facilitate the smooth transition of trust assets to its heirs? Should there be family discussions with parents earlier on to document and ensure their assets are adequately dispersed to their heirs? What do you do? How do you do all this when there are estranged relationships between parents and siblings or between siblings? In the two case examples that I mentioned, how did your mind change when you looked at the situation from the various perspectives? If there's a present opportunity in your own life to lay down some of the pretenses and issues that divide you and your parents and or siblings, there's contention, no one's talking, all that, will you reconsider this and get the ball rolling to bring unity? If not, why not? Who will end up losing, be left saddled with a bag of unforgivingly heavy rocks, and be sitting on your own 1 yard line of life? Well, thank you for joining us. Today we explored estate money to siblings and or grandchildren, highlighting the importance of open conversations in financial wellness. And we want to hear from you at Tunabudget.com. Submit your candid conversation memo and share your insights. If you enjoyed today's episode, please subscribe for future podcasts. Until next time, visit Tunabudget.com for your free Tunabudget worksheet plan, the most powerful budget sheet worksheet plan in the world, yours. Thanks again.